So you guys, welcome. Thank you guys for coming and being here on time. Truly appreciate it. For those who do not know me, my name is Kiera Perry. I am the CEO of Regal Realty Group ATL with Keller Williams Atlanta Partners, and I have been doing real estate now full time for 8 years, which is crazy, almost a decade. And I've learned so much, and it's been such a rewarding experience. And I am very passionate about what I do because I'm able to help people every single day build and create legacy and generational wealth through real estate. And so, that is the purpose of today's meeting. I have one of my partners in real estate is Lueder, Larkin Hunter. It's a law firm, and they have a lot of different branches of what they do. I've mostly am centered around real estate, but one of the partners invited me to a trust and estates class about this time last year. And I was like, this is information that my network and my people need to know. I'm very, very passionate about bridging the gap when it comes to the wealth division amongst minorities and a majority. And so this is another step outside of ownership that can kind of put us in position to have wealth and it sustain throughout generations and generations. And so I'm super excited. I'm here to learn today as well. So we have our special guest on, Mr. Barley. I'm going to let him introduce himself. He has an amazing presentation, but we do like for you guys to be very interactive. And so if you have questions, please raise your hand, use the raise your hand reaction tab there. That is totally fine. If you have questions, you can also put them in the chat. That is totally fine as well. So without further ado, I'm going to let our special guest, Mr. Barley, introduce himself.
Good morning, Kiara. Thank you again for allowing me to speak. I know this is an important topic, passionate to you and definitely myself. I think it's important that we appreciate and understand the importance of we're in the phase of acquiring wealth. Well, how do we make sure that that wealth is properly transferred to our loved ones when we are no longer able to be with them? And so I appreciate the opportunity to always speak on this topic. My name is Tua Barley. I'm a partner with Lueder, Larkin Hunter. My main office is out in Conyers, but we have about 30 offices in the metro area. I am the estate planning attorney for the firm, so I handle the estate planning practice for the firm with wills and trusts, and so part of that this conversation this morning is talking about that. I can go ahead and share my screen. I've got a presentation to give. It's going to be relatively short. This is a topic that's somewhat complex, but what I'm trying to leave you with this morning is just a general sense of what you need to do to prepare for either you directly or your clients if you're in the real estate or you're a professional that has clientele, making sure that they're at least planning for it. And one of the key things I want to leave you with is just organized, becoming organized. And I think that's the key to estate planning. We know where everything is and what we have. But the problem is the minute we're not here, whether we are disabled and can't communicate or we've passed away, can any of us say that somebody will be able to step in and know where everything is, from our smallest bank account to our social media password? If the answer is no to any of that, then estate planning is key in making sure that those things get done. So I'm going to go ahead and share my screen, and hopefully Kiara, if you can let me, share my screen.
Yes, I will absolutely make you the host. But before we start there, I just want to do a few housekeeping things. So if everyone can just stay on mute during Tua's presentation, that would be much appreciated. And again, like I said, if you do have a question while he's presenting, please feel free to use the reaction emoji to raise your hand, or you can type it in the chat. All right, let me make you the host and we can keep it moving. Okay, you should be good to go.
All right. So everybody should be able to see the screen. If you cannot, just let me know. But you should see a blue screen with estate planning on it there. And so I'll be using that. And let me just make sure. Perfect. All right. So again, this morning's conversation is about estate planning. As it mentions, is for planning for life, disability, death, and beyond. One of the key things about estate planning is that people think it's planning for death. and that's the only thing that I need to be worried about. But what I need to impress upon everybody is that the majority of us are going to go through a prolonged period of disability before we pass away. In fact, I think it's about 60 to 70% of us will go through a period of disability. So the question is, how do you continue to maintain a certain level of control while you are disabled? And so we will talk about some of the documents in that process there. Yeah. So let's, as we do with any topic, we have to define what we're talking about. And so in this case, we're going to define estate planning. And that's why I mentioned estate planning and not wills or not trusts, because those are the documents to estate planning. Estate planning is sort of the overall holistic approach to things. So from a individual standpoint, estate planning is I want to control my life, my property while I'm alive and well. Pretty self-explanatory. When you're alive and well, you're in control, no issues, no problems, you know where everything is. And so that's not a concern. As I mentioned before, it's the next phase that we're starting to be more concerned about, but it's taking care of myself and my loved ones if I should become disabled. Again, we're all going to go through a period of disability prior to us passing away. Now, I don't know if you would say it's the lucky ones that get to not wake up the next day and just automatic, or it's the ones that go through that period. But either way, you have to make sure that you're addressing that particular inevitability. And then the third part there is giving what you have to whom you want, the way you want, when you want. It's the ability to be subjective at this point. You've worked hard over your life to acquire assets. And so at this point, you get to dictate how those assets get distributed. Yes, because you have 3 kids doesn't necessarily mean you need to give equally to all 3 kids. Perhaps you give in percentages. Maybe the relationships are different. Maybe they didn't listen to you and go to that your alma mater like they were supposed to. Things of that nature. You get at this point to be subjective in your decision making. And then lastly, you'd like to save every last tax dollar, professional fee, and court costs legally possible. And this is not saying that we're going to avoid the cost, but we are going to make sure we incorporate that in whatever plan that we select. So this is sort of our general definition. It's our baseline sort of definition to move us forward in this conversation. Again, there's a lot of information. I don't expect you to be experts at the end of this, but again, we'll have the opportunity as Kiara mentioned, if you do have any questions, definitely feel free to ask as we're going along. I'll try to keep track of questions. If not, just unmute and ask. What I always say as the attorney, people have the wants to ask personal questions. I really can't answer personal questions directly, at least not specifically. So I may give generalities when I'm responding, but please make sure but still feel free to ask those questions. So what are the most common planning techniques? If I took a poll of everybody here and I asked you what's the most common planning technique, I bet you the majority of you would not be able to guess what that most common one is. And so let me just share what it is. The most common planning technique is one that we all practice. It's doing nothing and dying intestate. So about 70 to 80% of the population practice this technique, where they don't do any sort of estate planning and they pass away without a plan in place. And so we'll talk a little bit about what happens in that situation in that case. And I think in this presentation, we may not dwell too much on it. So I'm going to tell you, but when you pass away doing nothing, it leaves everything to the state in terms of how things should be handled. And so within the statute, the state law, our statutory code, it actually says what happens to your assets if you pass away doing nothing. So if you die and you have a spouse but no children, the spouse will inherit 100% of your assets. If you die with a spouse and children, then the spouse and children would share equally depending on the number of children. And there's a little section in there that says, but the spouse can get no less than 1/3. But in general, it's just understanding that it goes based on how things work. Now, if we were dealing in sort of, I deal somewhat in two worlds. We have this wonderful kumbaya world where everybody gets along and everybody is great. And then we have this real world. Well, it's not quite that way. In fact, every time I meet with couples, I try to ask some questions that are not sort of direct, but they're trying to get to the underlying, because every couple, every parent will say they have the best children, without a doubt. But when you start whittling down with some of the questions, you start realizing it may not be quite the same. And so making sure that they understand, if you pass away without a will, that there are things that will determine how your assets get distributed. The other planning technique is owning property jointly. So anybody, if you own real estate with one or more, two or more people. So if two of you own real estate, owning property jointly, there are rules and laws as to how that real estate is sort of inherited once one person passes away. So in Georgia, there's two ways in which two or more people can own property. They can own property as tenants in common, or they can own property as joint tenants. The difference being that if you hold property as joint tenants in common, when one person passes away, their half of the estate, it doesn't automatically go to the survivor, it goes to their estate. Whereas if you own it as joint tenants, when one person passes away, their half automatically goes to the surviving person. Now in Georgia, the default is actually tenants in common. It's not joint tenants. So that means if you and your spouse own property, you have to have magic language at the end of your names where it says, let's say Tua Barley and Andrea Barley as joint tenants with right of survivorship. If that language is not there, then you are owning property as tenants in common. Why is that a problem? So if a spouse passes away as tenants in common, their half of the property doesn't automatically go to the surviving spouse, it goes to their estate. So you can see how there could potentially be problems there. That's why, again, coming back to the initial point on estate planning as a holistic approach, we always review these things with clients. So even if we're doing a will-based plan, and I'll talk about the difference between a will and a trust, even if we're doing a will-based plan that doesn't necessarily deal with ownership in terms of how people hold ownership, we still want you to review that to make sure that if you're creating a plan within your will, that it matches how things are listed out in your individual assets. The other planning technique is designating a beneficiary. You'll see this in your retirement plans, your 401k, your life insurance, your bank accounts to a certain degree, where you designate a beneficiary on that particular account. And this is what you call a non-probatable affair, meaning that by law, it would go directly to the person that you listed as beneficiary. Again, not necessarily an issue, but we know sometimes some of us will make these designations years before we actually pass away. And although things may have occurred during that period of time, either death, divorce, marriage, etc., we still have the beneficiary designated on a policy previously. So again, that's why we have a holistic approach here at the firm, where we're going to make sure that you double check to make sure that the beneficiary listed in that policy matches with whomever you want to receive under your estate plan. The next technique is wills. Again, in this conversation, we're talking just about wills, and we'll mention that. Other planning technique is powers of attorney. Powers of attorney are to handle your affairs while you're still alive. And this is really financial affairs. So everything outside of medical. So the powers of attorney are to handle paying your bills, your taxes, dealing with bank accounts, social media, anything that we sort of do today that we're able to do that we sort of take for granted. We need to, the power of attorney will allow our agents to be able to do that. In the real estate setting, you sometimes see it if you're transacting business and, for instance, you can't make a closing, you will identify an agent to serve as your power of attorney for a particular transaction. These power of attorneys in the estate planning world are general. They're there to handle everything because you, at this point, you cannot competently handle it for yourself. And so you want to make sure you have people identified. So whereas powers of attorney handle things for everything outside of medical, the advance directive is specifically for medical. That's where you will appoint a healthcare agent to make medical decisions on your behalf. The other part of the advance directive also gives the healthcare agent guidance. on what level of care to be given to you. Do you want to give them the ability to donate your organs? Do you want to give them the ability, if you are in a coma or have a terminal illness, do you want to be kept alive or allowed to pass away? So the advance directive not only appoints the healthcare agent to act on your behalf, it gives them certain guidance as to your level of care if you weren't able to communicate that to your medical professionals. And then we'll talk about living trusts, and I'll get into again the distinction between wills and trusts, because I know we've heard a lot of this language, and sometimes there's confusion as to what the difference between the two. So again, the next slide just goes into the powers of attorney and advance directive, gives us more information. Again, powers of attorney, I did put healthcare decisions there, but really powers of attorney are to handle everything outside of healthcare decisions. And then the advance directive is to make those medical decisions for you. Signing a will, it does. So let me, I think I go into this a little bit. Let me make sure I'm not, I apologize. Yeah. So let me give you the difference between the two. And I know it's sort of off in the presentation, but let me give you the difference between the will and the trust, and then we will come back and talk a little bit about that. But the way I always like to explain the difference between wills and trusts is by using the analogy of a vehicle, same make and model, whatever your favorite car is. So the will-based car, when you pass away, that car has to go into the shop to get tires rotated, oil changed, etc., before it's ready to go on the journey. With the trust-based car, when you pass away, because you've been doing tire rotations and oil changes throughout the life of the vehicle, it's automatically ready to go on that journey. So the difference being the shop in the analogy is the probate court. So with a will, when you pass away, that your executor has to take that will to the court to get the judge to appoint the executor, at which point that executor is then empowered to be able to act on behalf of your estate. With the trust-based car, or in the analogy, when you pass away, because you have all the provisions in there, you've identified your successor trustee, it's automatically ready to go. So it does not have to involve probate. So that's really the difference between wills and trusts, is the probate. And why do trusts avoid probate? It's because of an important feature that we call funding. That means that technically, when you create the trust, you have to redirect all your assets into the trust. So real property gets put into the trust. Your life insurance gets put into the trust. Assets get put in trust, so that when you die, you don't technically own the property directly. You own it as trustee of your trust, which really is there only for ease of transfer upon death. That doesn't mean you can't sell your property while you're alive or do anything with your assets. You can. You're just technically now doing it as trustee of your trust, as opposed to you individually. So that's really how it avoids probate. Nothing is in your individual name, and so it goes through that process. So let me step back a little bit. So the will does guarantee probate, which again is not necessarily a negative thing. Fortunately, we live in Georgia, and so probate is not a difficult thing here in Georgia. So if you plan appropriately for that, it's fine. It could be costly administration. The way we look at the cost of administering an estate from a will or trust standpoint is really whether you do the cost at the back end, which typically is what the will would be, or you do the cost on the front end with the trust. Either way, you are creating sort of organization so that your executor or your trustee knows where everything is and is able to act on behalf of the estate. With a will, it is sort of public record. And the next point there, possibility of multiple probates. So when clients come to me, we sort of make a recommendation as to whether we will put them in a will-based plan or whether we'll put them in a trust-based plan. One of the key factors there is whether the multiple probates could be potentially an issue. That means, for instance, multiple probates occur really around real estate. So if you happen to own real estate in multiple states, let's say you own a primary residence here and maybe a family home or a vacation home in Florida, if you pass away with a will-based plan, you have to probate in the state that you passed away, for instance, here in Georgia, and then you also have to probate where you have property in let's say in Florida. So with clients that have properties in different states, we tend to recommend trust for them because we would then fund their primary residence in Georgia to the trust, and we will fund their vacation home in Florida to the trust. And so now when you pass away, we don't have to do a probate in Georgia. We don't have to do a probate in Florida. So we really do sort of an analysis for clients because trusts tend to be more expensive than wills. And so you would think I'm trying to put everybody into a trust, and that's not necessarily the case. We sort of have to do an analysis to determine, hey, this is the reason why we recommend it based on the circumstances that you have. Wills can also be easily challenged by heirs. So again, going back to the conversation that I have with parents about their children or their loved ones, we try to get a sense of how that relationship works so that we can avoid challenges if necessary or as best as we can. As I tell folks, anybody can challenge anything. The question is whether they'll be successful in being able to do that. And so if we get a sense that, for instance, in blended families, there tends to be maybe a little bit more conflict, especially if the surviving spouse is not the parent of the children. We want to make sure, hey, perhaps a trust may be better because it's harder to challenge a trust than it is a will. But again, we put all of those into consideration. And then the last point, sometimes wills don't always control most property. As I mentioned, when there are certain assets that are what we call non-probatable assets, which are assets that by contract or by law go into a particular go to a particular person. And so the will wouldn't control that particular asset. Let's say your life insurance. If you put your life insurance in person A, even in your will, if you said your life insurance should go to person B, because you designated a beneficiary of that life insurance as A, it doesn't matter what you say in the will. A by contract would receive the life insurance proceeds. I see a question in the chat as to why trusts are more expensive. They're just a more complex document than a will, and so trusts tend to be more important. And then the key factor, at least on my standpoint, is that funding. That means, for instance, when I do trusts for clients, we have a final additional meeting where we're funding assets, meaning that we're taking assets and we're placing it into the trust. And so for real estate, we're doing deeds, transferring into the trust. For the bank accounts, we're working with the clients to get those assets in the trust. So that's why, in general, trusts tend to be more expensive. Can you open a trust without owning property? And I want to say it's not really opening a trust. I know sometimes there's a confusion between things like trust accounts. You can go to a bank or to your financial advisor and open a trust account. That's somewhat different than creating a trust. And so can you create a trust without owning property? Yes, you can. Really, again, what I want you to think of is the trust is similar to the will. It's that document that tells people how you want things to be handled upon your death. So it's not only real property that we're concerned about, it's bank accounts, it's life insurance, it's retirement, it's other assets that you may own. And so again, I can't necessarily tell you whether the will or the trust is a better fit. It just depends again on the particular client and their particular request and their needs. Now, I will say I tend to favor trusts because, again, as I mentioned, trust forces us to be organized because the main responsibility of the person that you're leaving behind to be responsible for your estate, whether it's called an executor, an administrator, or a trustee, is really three simple things. It's gathering your assets, it's paying off your creditors, and it's distributing those assets. Again, three simple things: gathering assets, paying off creditors, and distributing the assets. Three simple things, but it's difficult. Number one, gathering assets. If you're not organized, how is your person supposed to understand where your assets are? So estate planning, whether it's will or trust, forces you to be organized. Now, the trust tends to be more organized because you're now directing things into the trust. And so it's harder for the trustee to not be able to know where all of those assets are because they are in the trust. We create for clients the red binder that you see on my desk there. And I tell all clients the most important part of that binder is a thing called either trust assets or other accounts. You want to put in there statements, either your bank statements, your life insurance policy, anything that can identify where your accounts are. So it makes it easier on your fiduciary, the person responsible, to be able to gather those assets so that they can distribute things based on what you want them to do. So with trusts, again, same identical in terms of the will. It's the ability to be able to transfer your assets upon disability or death. And so really a trust is the legal document that creates that ability to do that regarding their money, their property, their assets, etc. So the person creating it is called the grantor or the settlor. And you're giving that authority to somebody else to make decisions, the trustee. You are typically the initial trustee, and then you're identifying successor trustees, similar to your executive. And then for somebody's benefit, so it's the beneficiary. So same general thing. Again, the main difference is that a trust tends to avoid probate if you make sure that everything is in the trust. We have a question that says, does your recommendation change based on the age of the person? Not necessarily. I think the key thing that you want that we think about are assets and loved ones. The more complex or the more different, and really the goals and objectives. So it depends on what your assets are. Like I mentioned, do you have real property in different states? You're clearly a trust client. Do you own a business? You're probably a trust client, because with a will owning a business, you pass away, there's a period of that probate where things are sort of in limbo. And so your business would tend to be in limbo if you are a will client. So I would prefer putting business clients in trust so that you can clearly say within the trust, hey, the business is to be managed by this person or is given to this people. And so there's an ease of transfer in that step. So age is not necessarily a concern. And what I'll say also is this: for this conversation we're having is sort of a basic estate planning conversation, which is wills and trusts. And in this case, we're talking about your standard revocable living trust. Please know and understand that there are multiple different types of trusts depending on different needs. So when we're dealing with older folks that have elder care needs, like, or Medicaid needs, there are some different trusts, Medicaid trusts, irrevocable trusts that come into play. So, but I don't want to confuse this sort of discussion, because we're really just having a basic conversation about estate planning, sort of the foundational knowledge. So hopefully that answered your question here. Rita asked, if I render your services to create a trust, what documents do I need to initiate the process? Great question. I think we'll talk about it here a little bit. But again, it's relatively simple. We have a questionnaire that you fill out that gives us some of the basic information about your loved ones, about people who you potentially want to have as decision makers. It also lists out all of your assets, so you can have a better conversation about who your bank accounts, your life insurance, your retirement, all of those things. So the questionnaire really starts the process of having those conversations. Yes, and there's a checklist. In fact, you'll probably get too many emails from us regarding all of that information. At the end of this presentation, I'll have a QR code that'll give you more information about our process and even how to download a free estate planning guide. So again, this discussion really isn't about me trying to garner any additional business. My main goal here is to educate folks about the importance of estate planning. So yes, there's an opportunity to do all of that. What is the minimum fee to acquire a trust? That's in when I give you the QR code, it'll have a rundown of the fees and costs. Our fees for individual trusts start at $3,500. For joint trust starts at $4,500. So it depends on again whether you're married or single and the complexity. And I always have to tell clients it depends on the complexity in your assets, because clients always tell me, well, is it going to be $3,500 at the end of the day? And sometimes they're asking those questions over the phone or even during Zoom. And my response is always, well, if you can tell me what color pants I'm wearing, I can tell you exactly whether it's going to be stick to that point, because you need to know more information about me did I wake up today and have a Zoom presentation with good folks and I needed to have something, or was it a more relaxed day because it was Saturday, or a holiday? You need to know more information about me, and that's what I tell clients. Until we know more information, I can't give you what that's specific. But I'll tell you, you won't pay me a sort of a dime until you get a sense of exactly what the cost will be. So we talked about the differences again between wills and well, start at least with the probate process. Ancillary probate, where if you're having to do probate in other states, again, that's probably where a trust would be over a will. Incapacity, that's the next sort of point. Really, the difference between the will and the trust, a trust becomes effective upon signing, whereas the will doesn't become effective until you pass away. And so within the trust, we can put certain disability provisions there as to what is to happen if you become disabled. With the will, we can't put it in there, but we make sure that you have additional documents, and I'll show you what a complete plan looks like. So even with a will or a trust based plan, you will still have some of those additional documents that we talked about, the powers of attorney, the advance directive, things of that nature as part of the plan. That's why I always tell people it's wills-based plan and a trust-based plan. It's not simply just a will or just a trust, because we have to address some of the other issues. Privacy is also sometimes a concern. Wills tend to be public, the trusts tend to be private. I try to tell clients, don't stress too much about that, because people aren't sitting there looking up probate documents to determine how much you have. So really, it's not that big of a deal in terms of privacy, but it is a consideration when you're determining whether to recommend a trust or will for a client. Speed of distribution of assets, again, probate in Georgia is not a difficult process, but it is definitely slower than a trust, because with probate, with the will, you have to go through the probate process, which can be anywhere from 3 to 6 months to years, depending on how many assets, whether your folks contest, and all this other stuff. Whereas the trust tends to be quicker because everything's in the trust. Hopefully, the trustee steps in and can now just follow the instructions as it relates to that. And again, I mentioned business interest. If you own businesses, I tend to recommend trust to you so that your trustee can continue to manage and maintain that business while you're disabled or if you've passed away. And then contestability, again, it's harder to contest a trust and a will, simply because, again, what I mentioned, the trust becomes effective upon signing and you become the trustee. And so typically it goes for years before you either become disabled or pass away. So it's a lot harder for somebody to say, like for instance, in my trust, well, Tua really didn't know what he was doing. What do you mean? Tua not only created the trust years ago, but he served as the trustee over that period of time. So you can't now claim he really didn't know what he was talking about. With a will, because it doesn't become effective upon death, folks can argue, well, Tua really didn't know because he created it 20 years ago and he either got married or divorced or had kids and they weren't incorporated in the will, or maybe one of Tua's kids took him to get that done years ago and change things. So there's a lot of things that can affect, again, the enforceability. Is that necessarily a concern? No, because we add the same level of provisions within a will or a trust, depending on whether we believe there's a likelihood of it being contested or not. But again, when folks are sort of in the gray area between wills and trusts, some of these things tend to determine whether we recommend a trust or will for clients. So we already know, based on some of this conversation, what may not work. So doing nothing may not work. Signing a simple will or just a will may not work. Owning property jointly may not work, depending on whether you own it as tenants in common or joint tenants. Naming a beneficiary sometimes may not work, especially if you did it years before you actually ended up passing away. Even a bare bones living trust, one that's not customized to your particular needs or circumstances, may not work. So what will work is what we call a fully funded living trust or a customized will. It's customized to you because it's planned for your particular needs and circumstances and goals and objectives and loved ones. It takes into account your individual circumstances and needs, and then it ensures distributions of the assets in the manner that you desire. So let's look at what a plan looks like, because I know we've had some discussion and questions about that. So again, a trust-based plan or a will-based plan. So in a trust-based plan, the trust is the central document for distribution. And in a trust-based plan, you also have what's called a pour over will. The will in this situation is simply a backup. It's there in the case that you forget to add assets into the trust, you pass away with things out of the trust. Your executor under this simple pour over will document is to take that asset, go through probate, get authority, and pour it over or add it into the trust. Now, one technicality is that you can only put guardianship provisions. So if you have minor children, you can only put guardian provisions in a will. And so in a trust-based plan, that pour over will also serve to include those provisions there as well. But both of those plans, trust-based plan or will-based plan, will have the next few documents associated with them. So a durable power of attorney, as we mentioned, it's to handle, you're still alive, but it's to handle all your affairs, your financial affairs, everything outside of medical. So now, as I mentioned, because the trust becomes effective upon signing, we can still put disability provisions in there. So maybe the question you're asking, well, why do you have a power of attorney if you're doing a trust? Really, it's because in case of people asking. So let's say you become disabled and the person that your agent goes to the bank to handle your bank accounts. The bank's going to say, oh, you have a trust. We want to see the entire trust, which again, they should never ask that, but most people don't know. And so instead of you going in there acting as the disability trustee, that person would go in there acting as the agent of the power of attorney. So they would just need to see the power of attorney and still have the ability to act on behalf of the estate or the trust. Then you'd have, again, the advance directive to handle medical affairs. The next form there, HIPAA authorization, we would have that form as well. For those who don't know, HIPAA is the federal law that protects the privacy of your medical information. And so we add that form in there because if you've identified healthcare agents to make medical decisions on your behalf, you also want to give them the ability to access those medical records so that they can make a better or qualified decision on your behalf. Anatomical gift forms we add in there in case you want to donate your organs and have not either signed up on your driver's license or any other method. Memorial instructions are there. They are not mandatory, but memorial instructions are just telling family members how you wish your funeral to be conducted. Again, it's just to give people a sense or a guidance as to what you want to have happen. You know, who do you want to officiate? What hymns do you want sung? What organizations you were a part of that maybe you want them to have certain services on your behalf. So, you know, I'm a joiner. I'm a member of a fraternal organizations. So I want them all to participate in my funeral. And unfortunately, I've identified it and my wife knows, but it just gives your family the sense of not having to worry about certain details because you've identified how things should happen. The other document is also a personal property memorandum. It's a fancy word for a list. Because we can't put every personal item in either your will or your trust, we just reference this document that says, if I have a particular personal item, this is who I want it to go to. Because what we end up finding, and this is sort of a fact, is that when somebody dies, your personal items literally grow feet and walk out of the house. And so you want to be able to avoid some of those issues by identifying in that list every personal, your most important personal items and who it's to go to. Now, in the will or the trust, we will put, hey, look for this memorandum. And if it's not there, then by default, I want my personal items to go to, and you would list the person within the will or the trust as to who it should go to. We mentioned again some of our process, I think questions answered. We typically have a client seminar. We have an initial consultation with the client. It's absolutely free. The only requirement for having the initial consultation is you have to have the questionnaire completed at least a day before. And if we're meeting in person, then you must bring canned goods to the meeting. Now, we offer virtual as well as in-person meetings because our clients, we are a large firm, as I mentioned, 30 offices, metro-wide. So We don't, and even though I'm in Conyers and I love the city of Conyers, we don't always have to come to Conyers for all our meetings. We can do it virtually. And then the only preference is that you come to Conyers for the signing. So we have an initial meeting to sort of gather the information. We next have a design meeting. So it gives you sort of a sense of this is the exact cost for the plan based on my review of your questionnaire, based on my review of your notes. This is how much this is what I recommend, whether a will-based plan or a trust-based plan, and this is the actual cost for that plan. And at the design meeting, the most important thing is you'll see a form or a document that on the left-hand side has your current plan. So if you were to pass away before we complete everything, it kind of gives you a 50,000 foot level view of how things would work. And then on the right-hand side of that form would be our recommended plan based on our conversation. Which documents will you be given? Who are going to be, who are the decision makers? We do, and just as a point of clarification, we have what's called a rule of three. I love my clients to identify three people in almost every decision-making category, so that if the first person's not available, you have a backup, and then you have a backup to that person, so that you're not having to make changes to documents simply because either people have passed away or they frankly do not want to serve in that capacity. So we have the design meeting, and after that, we have a signing meeting when we execute the documents. And after that, if you're in a trust-based plan, we have a funding meeting where we go again asset by asset and make sure everything is placed into the trust. And it's sort of a partnership where you may be getting some of those documents and then that get transferred. Now, again, there's a question on land trusts. And let me say this again, this conversation is foundational. It's really talking about revocable living trusts and standard trusts. I'll be upfront and honest. I'm not a big fan of land trusts, and I'll say this. So land trusts are a creature that were really created in certain states, primarily Florida. So within the Florida statute, it actually creates an entity called a land trust, which can serve primarily to own real property on your behalf. Why I'm not a big fan of it necessarily is because it sometimes can cause issues or problems. It's easy on people to create. So I can create a land trust and have my property go into the land trust, and I can conduct business under the land trust. As a closing attorney, when I see land trust information, I get, because we need to know the authority to be able to act on behalf of the land trust. And so people typically will just create a document and do that. What I always recommend to folks who have property, instead of trying to create a land trust, create an LLC, create a company that owns that property, and then be able to transact business under the LLC as opposed to a land trust. So hopefully that answers the question. But really, it's a type of trust. In Georgia, it's a creature of contract because Georgia hasn't created a law to say land trusts are here, but Georgia is also a state that says if you created via contract, we will still abide by it. It's just the difficulty of trying to conduct business under the land trust. So hopefully that answers that question. And so we're at the end of the presentation because I didn't want to take up too much time in case you had any questions. The QR code that you see on there is that ability to go in and get more information about our process, our steps. Also be able to download a free estate planning guide that sort of gives information about some of the things that I talked about here as well, but a little bit more detail. It allows you to schedule me if you want to do so. But this is an opportunity again to just answer questions. If you have any that you sort of held back in asking, just feel free to let me know. And Kiara put in the information regarding the my contact information. So again, feel free to give us a call.
This has been a wealth of so much knowledge. Truly appreciate you today, Tua, for being here. And I noticed in the chat, you guys, I did spell Lueder wrong. So please, I'm going to correct that. But if you guys can interact with us, give us your feedback, send us some emojis, send us some reactions. Let's thank him so much for being here. As he mentioned, we have about 15 minutes left. So please feel free to ask your questions. You can come off mute at this time. You don't have to raise your hand or do it in the chat. And Tua, forgive me if I missed this, but did you answer? It's one question in the chat. Hello, what is the minimum fee to acquire a trust? Was that question answered? Just want to make sure.
Yeah, well, yeah, I think I did. Our individual trust plans start at 3,500, and our joint trust plans, if you're a married couple, starts at 4,500. So it just depends. And I always stress the start because it's customized to the particular client, and so we always want to make sure we're addressing their particular needs.
Okay. Awesome. I know I asked a question earlier because I have spoken to someone before and they were saying, hey, I'm at the time, I think I was like 32, I'm 34 now, but they were saying, hey, a living will would potentially be a better option for you at your age. And so that's why I was like, is the age, is that a big factor into all this? Or do you think, because I do own a business, I do own a home, do I have potential for a trust? And then two, sidebar on that, I want to ask the question. We hear the term trust fund baby a lot.
Yeah.
And so for those people who do have legacy and they have nephews and they have sons and daughters or whoever they're leaving behind, what does that really mean when people say I'm a trust fund baby? Like, what does that mean for the people that are
Yeah.
coming up behind them?
Yeah, so I'll answer the first part. Age is not really an indicator necessarily for me as to whether you do a trust or will. You know, really it's about assets and it's about loved ones and it's about objectives. Once we sort of meld those three, then we get to determine because you could be 23 and not have many assets and not have any kids, or you could be 35 and not have many assets and not have many kids. And so that there's not a conversation. Or you could be single, 45, but you have a business, real property, and properties in different states. Yeah, that's probably something that you need to start planning. So age is not necessarily a concern. The only time age becomes a concern is if you are, let's say, older, and I really can't even say what that is in terms of specific numbers. But when you're older and we have to now start worrying about potentially nursing home care, when you start having to deal with that, then we start thinking about more things other than just will trust. Now we start thinking about Medicaid planning, but that's really the only time when age is a identifier in terms of what level of care. And then the trust fund baby thing, that it's a negative connotation, but it really is a conversation with the individual creating the trust as to what you want to have happen. Some clients and some folks really don't care. They're hey, when I die, I want my property and my assets to be split equally with my children. Others will say, well, when I pass away, I want my assets to be kept in trust for generations to be used for X, Y, and Z. That's really where the trust fund sort of moniker came about, is for people who had what I call legacy trust that last over years, that can be used towards what we call it's a HEM standard: health, education, maintenance, and support. So you set a criteria there as to that, as to how your beneficiaries can benefit from that trust over a period of time. I know personally, I'm concerned with creating trust fund babies, and so within my personal trust, I have, for me, it's about incentives. I want my whatever I leave behind, whatever small that I leave behind, to last generations, but not only to last generations, but I also want to incentivize mine to add to whatever I leave. So it's not so they get a sense of I don't just take. And so I think what I did in my personal, and I don't, and I'm only bringing this up for informational purposes, is I try to put a little bit of an incentive for my sons to add to it. So I say, if you just take what's there, you only get X percentage. But if you add to it, you get a higher percentage. And so what in my, at least what I'm attempting to do, and this is what I tell clients, you've got to mirror that with what you're telling them. So it's not, this is the first time they see the trust and they interact. No, this is things that you've been telling them in their upbringing, et cetera. And so you're just reinforcing those things. So that's what I try. And for any of us who have children, you know how difficult sometimes that is in trying to impress upon them the importance of taking what they have and building on it, as opposed to just being It's just here for my general use and need. And so it's a balancing act between not leaving enough where they're living off of it, but leaving enough where they're supplementing what they're already creating and leaving it for the generations that come behind so that they can be beneficial in that. So that's what the long answer to your short question is.
Awesome. Well, we have a question in the chat, so we're going to go with Joya's question, and then Rita has her hand raised. And then after that, guys, we are going to do a little raffle. So I'm going to ask a question. I always like to do a little raffle for you guys being here and participating. So that'll be coming after our next two questions.
And so Joya's question about the recording, I assume Kiara will share the recording of
Yes, we are recording, and we'll send a follow-up email next week, and you'll have the recording attached to that email.
Is there a checklist regarding how to start? Yes, that's part of the checklist that you can download. But the questionnaire, and once you communicate and contact us, again, I'm not, you won't be receiving any unsolicited stuff from me. So my contact information is there. If you'd like for us to assist you in your estate planning, just feel free to contact us, and we'll send you the information to get the process started. So again, no pressure in being able to do that. Are there any actions that we can take now to protect our assets? Perfect. So again, I refer back to that estate planning guide because it's sort of, I think one of the guide itself is made up of several articles. And I think one of it
Are you
is,
able to show that slide again for us?
oh, yes, sorry.
As you explain that, my apologies for cutting you off.
Oh, no worries at
I know
all.
people kind of some people struggled in at different times, so they might have
Okay.
missed certain parts.
Hopefully, can you see the slide? I thought I shared it.
I just still see the thank you slide. I don't see anything.
Yeah, so to the right of the thank you is a QR code. So if you scan that QR code, it'll take you to my website that you can download the guide, and that'll give you more information about the process. So yeah, definitely. And that guide will give you sort of steps on what you can do to start at least preparing for getting your affairs in order. How much does your company service cost? I think I mentioned that depending on the type of plan that you have. Will-based plans start at $950, individual trust $3,500, joint trust $4,500. So it just depends on what is recommended there. Was there any other? I didn't see.
Yes, Rita had her hand raised. So Rita,
Okay.
you can come off mute and ask your question.
Thank you so much. Kiara, just want to say thank you for providing this opportunity for us. This is very selfless of you and forward thinking, so thank you. Attorney Barley, thank you also for this informative presentation. Definitely giving me a lot of meat to chew on. I want to ask the question about estate laws. I know that they change. I don't know how often they change, but if I initiate and you are the attorney to handle my trust, to create that for me, will you continue to keep up with us and with the state laws to help us continue to keep up with adding to or to modify that trust?
Yeah. So that's a great point. And the short answer is yes. The longer answer is this, I tell clients all the time, we can only take a picture in time as of the time we do create the asset. There's a sort of a joint obligation. Will I, if laws change, will I be contacting every client that I've done to say, hey, there are changes? Yeah, we're developing a process or a newsletter where you'll get a newsletter that says, here are the changes and differences. Now, why that's not a big concern necessarily is because either the trust or the will is a contract. And Georgia, for the most part, just says, we will abide by whatever contract that you create. Georgia just adds certain incentives. So let's say the last big thing that occurred was that Georgia took the power of attorney and put it into the law. And so what that does is it tells folks like me, rather than trying to create a new document, let's use the Georgia statutory form and maybe add. So like, for instance, in my firm, the statutory form is only about 8 pages, but my power of attorney is 32 pages because we add additional powers, some that you may not, because the thing we always think about is we add things in there. It's like the baggage in a suitcase. Like if you're going on a 3-day trip, you pack for 8 days just in case something happens. And so you look at your trust or your will in that same vein. We add in things within the document that you may not ever need, but the minute that you need it, we want to make sure it's there, because the worst thing that can happen is if you need it and it's not there, now you have to go to court to get that authority. And so that's how we look at those things. So really it's a joint thing where we're yes, we are guiding clients on changes, but I don't want clients to be too concerned, because the changes that occur are only enhancing things. They're not taking away from what it really you've already created. So unless death, divorce, marriage occurs, you should really be sound in the documents that you create at any point in time.
Thank you. Sounds good. Thank you.
You're welcome.
Awesome. So we're going to go ahead and wrap up with the raffle. But my last question for today for you, Attorney Barley, would just be, I know a few people are on today who don't necessarily live in Georgia. What would be your advice for those people to look into the estate laws for their state?
Yeah, great question. In fact, it's relatively simple. So I refer most people who don't live in Georgia to this website. It's real easy, estateplanning.com. So if you go to estateplanning.com, I'm part of a national network of estate planning attorneys called Wealth Counsel. And Wealth Counsel provides support in terms of documentation, other attorneys, et cetera. So if you're living in another state and you want somebody similarly educated and supported like myself, then just go to estateplanning.com. It gives you more information, but it allows you to put in your zip code or your address, and it'll come up with all the attorneys near you. And so you can, and I always say, interview them to make sure they're a proper match, that they fit your particular needs, and they'll be able to sort of guide you. So although my information is Georgia specific, in some cases, it is general. In some cases, at least it gives you a starting point, but I would direct you to estateplanning.com for more specific state laws or requirements.
That's awesome. Great to know. So we're going to end with our raffle, and the question is, it can only be answered in the chat. I think I cut out. Can you guys hear me now?
We can hear you. Can't see you too well, but we can hear you.
Yeah, I don't know what just happened. So you can only answer in the chat. The first person to answer the question will get a prize. So the question is, what is the main difference between a will and a trust?
With that drum roll. Rashana.
Okay, Rashana, congratulations. Is that the correct answer, Attorney Barley?
That is the correct answer. Probate is the primary difference between a will and a trust. Yes.
All right. So Rashana, I have your information. I will send you your gift card. Thank you guys so much for being here. I don't know why my screen is blurry all of a sudden, but hey, these things happen. Technology difficulty sometimes. But thank you, Attorney Barley. We just appreciate your value here. I know that a lot of attorneys have retainers, and so we took about an hour of your time today. So this was very, very much appreciated. So we thank you for doing this for us and volunteering your time today. So I've already received so many texts and just information about how informative and valuable this was, including the comments and the reactions. So we have to do this again. We'll have to come back and do a part 2 because we had over 25 people on this call today. So I feel like it's so many more people we can reach to get this information. So thank you, thank you, thank you. People are saying thank you in the comments. Thank you guys for joining on an early Saturday morning. Truly appreciate you guys. Again, we will send follow-up information out to you guys next week. So be checking your emails after today for the follow-up content. Thank y'all for joining. Have a great Saturday and happy November.
Yes, thanks for having me. Have a good one.